All right, so we'll get things underway for panel 3 here, U.S. monopolization law. What are the legal obstacles to enforcement, and can they be overcome? We've got a great panel here. Immediately to my right, we have Lena Khan, who's currently Director of Legal Policy at Open Markets Institute and a visiting fellow with Yale Law School. She's previously been with Open Markets Project at New America, where she researched consolidation across sectors, including tech, media, finance, retail, and commodities. She also, is it the most famous law review article ever written? I mean, she wrote an article, a law review article about Amazon that got, 80,000 views, at least last time I checked, which has to be some kind of record. So we're excited to have Lena, the most famous most famous law school student of all time, maybe. We've got Scott Cleland. He's president of Precursor, a Fortune 500 research consultancy specializing in the future of internet competition, property rights, privacy, cybersecurity, and cyber ideology, algorithmic markets, and communications competition and deregulation. He authors the Precursor blog and serves as chairman of Net Competition, a pro-competition e-forum supported by broadband interests. Scott also recently published a really interesting paper for the American Enterprise Institute, so we've been lucky enough to have a couple of American Enterprise Institute scholarship scholars here today. So, and Scott provides an interesting perspective on consolidation from the conservative side of the aisle. And we also have Sandeep Vaheesan, who's counsel in the Consumer Financial Protection Bureau's Office of Regulations. He works on the CFPB's rulemakings on debt collection and small dollar loans, also provides regulatory guidance to other CFPB offices and the public. He was previously special counsel at the American Antitrust Institute, and today we'll be hearing from his sort of antitrust scholarship hat, and we're very pleased to have him as well. And so we'll kick off the panel with a few remarks from Scott to start things off.
Well, thank you for having me, and also the topic of this panel, when I was thinking about it, I decided to write a white paper because it got me thinking, and I had a lot to say, and I thought I better write it down and explain it. It was just a good opportunity because, as I'll explain, there are two big problems here and obstacles to addressing the issues. And in a nutshell, the biggest one is there's a very incomplete understanding of the problem itself and the breadth and the how far along it is. And also then that there's, I think, very little understanding of the root cause of the things that are going on. So those are the two big obstacles, but let me go back and just frame it a little bit. I think it's very important to be open about where one's perspective is coming from. And so I'm a rare person, I'm an internet competition analyst, really, and I'm not a lawyer. And I'm an antitrust analyst, first as an investment analyst and now in what I do now. And just, so I look at the world differently. The two things that my clients, I think, value is I see the world whole and I anticipate well. And so that's why I'm the Precursor brand. I'm an entrepreneur, I'm a capitalist, I'm a conservative, and I look at antitrust, and people say, why is antitrust a big issue? Well, any conservative, and I think most Americans know that separation of powers, competition among the branches is essential in our Constitution and in our democracy to prevent tyranny. Our founding fathers were really smart. Well, antitrust is essentially the separation of powers of competition and of the private sector. And I think it's equally valuable because you can have tyranny in the private sector just like you can have tyranny in the public sector. Obviously, the private sector doesn't have an army and a police, but they still can cause a lot of the trouble. So that's an important context. So when I talk about an incomplete understanding of the problem, what I've done in this white paper, and you can get it at googleopoly.net, it's the top entry. It's Googleopoly 27. I've been doing this now for 12 years or 11 years with them. But it's very heavily researched, and what I do is what I wanted to do is say, first of all, the obstacle is you can't even begin to start addressing a problem if you don't even have a sense of the breadth and depth and the maturation of the problem that's being addressed. And so what I've done is in it summarized basically that we have three Standard Oil-like monopolies now. I call them, they're standard distribution network models, much like Standard Oil was or an AT&T was, not so much like a Microsoft was. And what's important insight here is these three, the big three are Google standard data, so, Facebook standard social, and Amazon standard commerce. What you have to realize is that from a monopoly standpoint and the strategy and what you do and how you do it and where you leverage it, those three are the same model and they're alike. What's different is the stuff that they put through their process. So don't be mistaken when you tear it down and you look at it analytically and you understand how does this business work, how does it get dominant, how does it act either competitively or anti-competitively. It's the same model done just in three different areas, one with information, one with what's shared and communicated, and the third obviously with commerce and with products and services. And I'll tell you more on that. And then when you look at these three, what I do is I lay out, this is how they are dominant. This is why their dominance is enduring and expanding, and then what are the harms from that? So laying out, I think, when you read the papers and whatever, the last 6 months, people now realize their monopolies. And I think that, there's this debate where people, like on Amazon, will say, oh, well, they're not a monopoly. How can they, with 4% or 5% or 10%? What it is they like to define what the business that Amazon is in to their favor. And Lena's done just outstanding work on that. But really, when you look at Amazon, you have to see it as like the Standard Oil of commerce and how they are trying to be the end-to-end dominant distribution network. And when you look at it that way and you look at the shares and you look at the numbers and whatever, they have got 90% of the supply with Amazon Marketplace and 90% of the delivery demand. So we have three. Now the big thing here is that's what everybody understands. So this is nothing news here. What I want to say to you is people don't realize what else is going on. I wrote 2 years ago, or about a year and a half ago, that there's also a cartel behavior in digital advertising between when Google and Facebook decided to stop competing. But what I did in the white paper, and I'll just go over it very briefly, is the problem we have in America is not only do we have three monopolies, and we haven't had anything like that since, for several decades. What's happening right now is way worse than the 1880s. And people think, well, are these monopolies? They are monopolies. I mean, and the question can be, did they get their monopolies legally or illegally? Won't address that right now, but they have been in the process of monopolizing, and they are very, very far along there. What is different now is if you look at the problem like a cancer, and this is a cancer against competition, is you could say stage 1, that's not so serious, stage 2, stage 3. This is stage 4, the worst of cartelization. And what I document and describe is this market has three monopolies, not competitive, that have decided not to compete, and they're cartelizing. I'll mention 4 different functions in the economy, and that is way beyond what people realize is going on or how bad it's gotten. So you need to understand that cartels are usually competitors with not necessarily a dominant or 30% share or whatever that collude and come together to try and create monopoly power. Why this is so bad right now is you have 3 companies that have monopoly power. And they're coming together at the broader economic level to cartelize entire economic functions. So let me just run through what they are. And when you look at the white paper, you want to see page 9, where I've put it into a chart. And for those that haven't seen it, it's basically showing it's a bottleneck economy, where on one side you have 90% of online demand that has been monopolized by Google, Facebook, and Amazon, and also on supply. So you have gatekeeper and tollkeeper power coming together, and when you put the three of those together, that's about half of the economy. So that bottlenecking, why care? Well, what's happened is these are intermediary platforms. Is essentially the economy, the invisible hand that we all knew pre-algorithmic markets and pre-intermediary markets like this. And remember, every other intermediary kind of brokering model out there has been regulated, is regulated, because there's inherent problems with intermediary markets that don't have any oversight of any type. And so what you have is half of the economy now is going in the dark and going through algorithms, and people imagine that those algorithmic hands do the same thing that the invisible hand do. They don't. These are programs that have, if then, at the very basic level, they know what they want to achieve. This is a programmed economy. As a conservative, I find it outrageous. We have a centrally planned, centrally executed economy, and everybody thinks it's a free market. We don't have a free market. We have a favored market, which I will get to. Cartelization of digital advertising. You're going to have, the two, Google and Facebook, they are not competitors, they are complements. Amazon is going to roar into this space. It's going to be more disruptive than the two. It's going to accelerate very fast, and it'll be the third member of that cartel. And why does that matter? Oh, that's just the way the economy monetizes content. Just a minor thing. And then we do search cartelization. There's a dynamic where, in 2013, there was Facebook, Microsoft, and Apple were very aggressively looking to compete with Google in search in one way or another. Now, basically, Google took out Facebook, took out Microsoft, and just in September, Siri now does voice search with Google. So in mobile, all search now that matters is being done by Google. So they've cartelized that by basically by turning those folks from rivals to buddies. And then you have the cartelization of startup capital, the American Keiretsu. And basically, all of this, the reason why we never have to worry about these technology markets is there's a garage entrepreneur that's just looking to mug Google and Facebook and Amazon and take their lunch money and take their franchise. The thing is the startup culture has been totally cartelized. There are so many moats and alligators and fences and razor wire to ever get to these guys that the big three. And I do I do a little vignette about the Keiretsu, but it just shows they either NDA them and steal their information, or they co-opt them through an early stage, or they crush them, or they Keiretsu them. And so this notion of disruption is pure fantasy. The disruptors are the big three, and they are completely protecting themselves. And it's precious when you look and see how much overlap there is. I'll leave that to encourage you. But the thing that I'm going to tell you that's unique today, that is the root cause for this mess. How could this happen? How could it be so bad that we have 3 monopolizations in process and 4 cartelization over some of the most important economic functions of the economy? Not of a sector or whatever, but of the entire economy, of the largest economy of the world. And what this is I know, because this is what I've been doing for years, is we have had a 20-year internet-first industrial policy. It's, anybody that knows the Telecom Act knows that, they're protected in Section 230 from being regulated. They're protected, they're immunized from any liability. Liability is also accountability or responsibility called corporate responsibility, which every other company has, but isn't immune for doing something wrong. So we have had for 20 years, the federal government has aided, protected, benefited the entire, the electronic framework for global economic, commerce, the Telecom Act. They were very successful industrial policy in creating the biggest, best internet infrastructure and ecosystem in the world. The problem is, once they did that, the monster kept growing, and now it's monopolizing and cartelizing. And it's really simple why. When the government chooses one sector and competitively favors them to win up and down the stack, they win, and it's called winner take all. Once again, anybody that imagines that these intermediary markets are a free market, they're not. They're national champions, and it's in law, and in the white paper, I show you it, you just read it, and you're gonna go, wow, the history. Remember, the internet was invented by the DOD. It ran in the government for 20 years odd before it got privatized, and they really didn't let go of it. And so what I'm telling you here is that there are 3 anti-competitive standards that are embedded. I've named them something different than they are to let people see them. The first one is, it's basically a competition double standard. Now you may start thinking, oh, now I know why antitrust is so screwed up. There is a competition law that is in conflict, that is at war with antitrust law and enforcement, even though it wasn't supposed to because it was exempt in the 96 Act. But anybody knows it has. And basically, if you're an information technology company that got into communications, you're totally unregulated. However, if you're a communications company that does information technology, you're totally regulated. And since for 20 years now, those technologies do the exact same thing. It's called the internet, and it's internet services. Whoa. So 2 entirely different sectors are doing almost identical same thing. One is heavily regulated, the other has 0. Who is chosen to win, who is chosen to lose? The second one, I'll wrap up real quick, is the Wild West standard, where basically one group, internet companies, where basically says, do whatever you want. So they're like the ranchers and whatever that basically, it's out there, it's Wild West. You take whatever you can and you do. That's what's happened. Yet everybody else in the economy is civilization and have to play by civilized rules. Who do you think wins in the Wild West when somebody comes with all their guns and ranch hands, and you're the little settler, the homestead or whatever? And no one's there to hear. I mean, that is what, and people scratch their head and go, what about all the things that are going wrong in our society, all the polarization, all that kind of stuff? Well, I list a lot of those things, and it's surprise, surprise, when you have a policy that has a dual class of accountability. Some Americans are not accountable to the rule of law or whatever, and the others are. The last thing, I call it the tech welfare standard. Section 230, which is a liability protection, immunity from liability, it's tech welfare. No one else is basically protected or immunized, much like a diplomat is immunized from whatever they want to do when they're in the United States. We gave these companies diplomatic immunity, and surprise, surprise, they do whatever they want. So the 2 obstacles, number 1, people don't understand how bad the problem is. Number 2, there's hardly any discussion of what the root cause of almost all of the problems and why it's relevant is why we know only 3 intermediary companies are monopolies causing problems.
Okay, perfect.
Thanks.
Let's move to Lena and her prepared remarks.
Sure, so thanks to the Capitol Forum for inviting me and for putting on this interesting discussion. So when considering monopolization law in the context of the dominant platforms, I think it's helpful to think of 4 buckets. The first bucket is anti-competitive conduct that current doctrine can reach that enforcers should pursue. The second bucket is conduct that antitrust should cover but probably can't, either because the doctrine has been gutted or because the kinds of anti-competitive conduct we're seeing are ones that the current law doesn't register. I think a lot falls in that second category, in part because of the consumer welfare approach that antitrust is now focused on. Many of the platforms are engaging in forms of anti-competitive conduct that might not necessarily lead to short-term price increases, and so therefore not trigger antitrust in a traditional way, even though we are seeing harms to competition. The third bucket is conduct that antitrust should cover, but where the parameters are kind of unclear, so we're not sure if it can. And fourth is conduct that raises competition concerns, but that probably should not be addressed through antitrust, and should probably instead be addressed through some regulatory regime. And we saw some of that debate play out earlier on the net neutrality panel. So in considering what conduct in tech platform markets raise competition issues, there are a few concerns that rise to the top of the list for me. So the first is the conflict of interest that is created by the fact that many of the dominant platforms are highly integrated, thereby competing with the very businesses that are now dependent on their platforms. This creates, a core conflict of interest that these firms can and do exploit, privileging their own goods and services. The Capital Forum has done some terrific reporting showing how this pans out in the case of Amazon and kind of the apparel market. In terms of thinking about how to address this, you could try to form a theory of harm around potential harms to innovation. One of the key ways in which Amazon abuses this conflict of interest is that it uses its third-party marketplace as a petri dish to basically identify what goods that other merchants are introducing are doing well. And then it kind of steals those insights, directly goes to the manufacturer, introduces those products, undercuts the original merchants on price, and kind of docks them on search results. This is a similar strategy that it's adopted when it comes to rolling out its private brand and private label. And if you think about kind of incentives this creates, if you are an entrepreneur, if you're a small business and you're thinking about bringing a product to market, you're kind of in a bind because on the one hand, you want to use Amazon's platform because it reaches so many consumers, but on the other hand, you know that there's a good chance that you will be the one undertaking the initial risk, but if that risk leads to profit, it'll in fact be Amazon that reaps from that. So I think, you could try and form theories of harm around that. I think other approaches would be to introduce a kind of prophylactic ban that says dominant platforms should not be able to compete with any of the companies that depend on their platforms. Prophylactic bans have a long tradition in competition law and are ones that we've adopted in other sectors. The second issue that comes up for me is monopoly leveraging. So as Scott mentioned, these companies enjoy monopoly power, and in some instances, they might have acquired that power legally and fairly. But what we increasingly see is that these companies are using their monopoly power in one market to expand unfairly into other markets. And so the technical definition of monopoly leveraging is when a company uses its monopoly power in one market to engage in anti-competitive conduct that creates a dangerous probability of monopolizing a second market. So Europe found Google to be using its monopoly in search in anti-competitive ways, creating a dangerous probability of monopolizing shopping services. And so this is, something that we see routinely with these platform companies as they're basically adopting monopoly leveraging strategies. The law here is somewhat unclear. Circuits are split on whether monopoly leveraging is an independent theory of liability and on what that showing would require. The Supreme Court addressed monopoly leveraging in a footnote in its 2004 Trinco decision. It basically acknowledged monopoly leveraging as a valid theory, but did so in a very crude and undeveloped way that also cast doubt on the legal viability of the doctrine. So I think this is one area of the law where the parameters have not really been tested and where I think enforcers should be moving forward and kind of coming up with strategies to test what the parameters would be. The third issue is predatory pricing. So this is a tactic that Amazon has pursued pretty aggressively. These are winner-take-all markets, so chasing growth and market share at the expense of short-term profits is highly irrational. This is an instance where the doctrine is clearly at odds with the reality of how digital markets work. Predatory pricing used to be illegal for most of the last century, but starting in the late 80s, the Supreme Court introduced a recoupment test that's basically premised on the idea that predatory pricing is highly irrational, and so they introduced a test, a burden of proof on the plaintiffs that is extremely difficult to meet, and practically speaking, predatory pricing litigation has plummeted since. I think the path here is that we really need a new law, either through legislation or through a new course charted by the Supreme Court. The fourth issue that I see as raising competition concerns is the systemic information advantage that platforms have acquired. So there are several instances in which these platform companies, either by virtue of being so integrated or by virtue of having acquired particular technologies, now enjoy a systematic information advantage over their competitors. So one example of this is Facebook's acquisition of Anavo several years ago. Anavo is a technology that basically technically, is a privacy-enhancing technology, but what it also enables Facebook to do is track very closely what competing products are diverting attention from Facebook. And so in this way, it's able to identify which companies could emerge as serious threats because it's able to see, where users are flocking. And this is a strategy that Facebook has used when, acquiring other companies. And I think it's also worth noting that given that Facebook has this early insight, it's able to then acquire companies at a much lower sum than what it would have to pay if there was if it didn't enjoy this informational advantage in this way. And this is something that, in addition to with Facebook, you also see with Google and Amazon. I think there are at least two ways to try and address this. One would be to force companies to spin off the technologies that give them this advantage. The second would be to impose firewalls, limiting the kinds of information that a company can share between lines of business. So another example of this kind of dynamic is with Amazon Web Services. A few years ago, there was a report that Amazon Web Services was basically tracking which companies were growing their usage of cloud computing most quickly and identifying those as fast-growing startups, and then it was using that information to invest in them through its venture capital arm. And so you see how it was kind of using information collected in one line of business to privilege another line of business. So I think imposing firewalls would be one way to try and address that, though I think there's good reason to doubt that firewalls would be very effective. The third way to potentially address this would be to revise how we do merger enforcement. So not necessarily to rely on Hart-Scott-Rodino to be the one mechanism that triggers review, but instead to maybe automatically review acquisitions by dominant platforms, given that we see Facebook increasingly acquiring companies at their very early stages and therefore sometimes paying for them amounts that don't trigger review. And then only years later do we realize that actually tilted this entire market and there was no government oversight over that. So I think those are the four instances those are the four issues that I think raise the most competitive concerns for me. And I think oftentimes when we're discussing platforms, there is this general sense that these are new technological companies and they're kind of flummoxing antitrust law and there's nothing really we can do without new law. But I think it's important to recognize that there are in fact areas of the law where the parameters have not been fully tested and that enforcers or private parties could be bringing litigation to try and kind of come up with theories of harm that the courts might go for. I think we're at a really interesting moment right now. Conversation around the potential ways that dominant tech platforms are undermining competition is very lively at the moment, and I think we're at the point where that conversation is starting to shift from merely the recognition that there is a problem to actually figuring out the ways in which we might address this problem, and I think it'll be a really exciting topic of discussion for the years to come.
Sandeep?
Sure. I'd like to thank the Capital Forum for inviting me to this great event and stress at the outset that these are my views alone and not those of my employer. So I think if you talk with members of the antitrust bar, there is a common perception that anti-monopoly precedent is categorically bad today, and hostile courts make it nearly impossible to win Section 2 cases. So as a result, even among people who are supportive of greater monopoly enforcement, you see this common attitude of resignation and pessimism, basically saying, sure, the agencies could bring cases, but they're certain to lose in court because the courts just don't like Section 2. I'd like to present a counter-narrative and argue that reality is actually significantly more complicated. The case law we have today is mixed rather than categorically bad. And importantly, the Federal Trade Commission has substantial power to rewrite much of antitrust policy today. So instead of just looking at the courts and accepting the continued inaction on the monopoly front, we should be demanding more from our enforcement authorities. So I'll start by presenting the unhappy story. There's no question, the Supreme Court has erected major obstacles to bringing two types of claims: predatory pricing and refusals to deal. So on predatory pricing, you have the Brook Group decision, which established a two-part test that Lena alluded to. Plaintiffs must show below-cost pricing as well as a dangerous probability of recoupment. And the recoupment prong is especially difficult to satisfy. So as a result, we've seen relatively few victories on predation claims in the past 25 years. On the refusal to deal front, Trinco and Linkline decisions from the past 15 years have greatly narrowed the scope of refusal to deal liability for dominant firms. And beyond restricting the scope of liability, Brook Group and Trinco cast a wide shadow with some empirically unsupported dicta, called them the penumbras of Brook Group and Trinco. So in Brook Group, the Supreme Court said, predatory pricing is rarely tried and even more rarely successful. And in Trinco, the court said, the opportunity to charge monopoly prices, at least for a short period, is what attracts business acumen in the first place. It induces risk-taking that produces innovation and economic growth. So this is a very Schumpeterian view of the capitalist system. So as a result, lower court judges who are hostile to antitrust and supportive or even indifferent toward monopoly have plenty of problematic language on which to draw. So this is the unhappy story that's out there. But notwithstanding these unfavorable precedents, plaintiffs have actually won a significant number of monopolization cases since the year 2000. I think the most notable successes have happened on the exclusive dealing and loyalty rebate front, where the Third Circuit, Sixth Circuit, and 11th Circuit have issued very positive decisions. And even outside of this area, you see important wins. So last year, the state of New York won a major claim against the pharmaceutical company Actavis over allegations that Actavis engaged in exclusionary product redesign. And even on predatory pricing, in the wake of Brook Group, plaintiffs have won cases. So I'm thinking specifically of the Sixth Circuit decision in Spirit Airlines versus Northwest Airlines from 2005. These were not just sort of narrow technical victories. These opinions often affirm the importance of anti-monopoly as an economic and political principle. So in the 2003 case, LePage's versus 3M, the Third Circuit wrote, Section 2, the provision of the antitrust laws designed to curb the excesses of monopolists and near-monopolists, is the equivalent in our economic sphere of the guarantees of free and unhampered elections in the political sphere. And in 2001, the DC Circuit in United States versus Microsoft wrote, it would be inimical to the purpose of the Sherman Act to allow monopolists free rein to squash nascent, albeit unproven competitors at will. So in these opinions, courts are interpreting statutes in the way that they always should in a democratic society. They're looking to the congressional purpose underlying the statute and not just being guided by the writings of Robert Bork, for example. So moving outside of the courts, the FTC actually has a deep reservoir of unused power under Section 5. Under modern administrative law, the FTC can use Section 5 to really rewrite much of antitrust policy. Importantly, Section 5 was intended to be an incipiency statute. It was meant to prevent competitive problems, really nip them in the bud, rather than wait until they have blossomed and taken hold of entire markets. So the FTC can and should use Section 5 to strengthen prescriptions on monopolistic conduct. For example, the FTC, through adjudication or rulemaking, can restrict monopolies and near monopolies from maintaining and acquiring dominance through below-cost pricing, exclusive dealing, tying, and refusals to deal. And although Section 5 has been interpreted narrowly in recent decades, administrative law gives agencies broad freedom to change course and revisit longstanding interpretations. So under new leadership, the FTC could put forth a much more expansive interpretation of Section 5. So in conclusion, the overall anti-monopoly legal landscape is mixed and not nearly as bleak as some would claim. We've seen important plaintiffs' victories over the past 15 years. And if anti-monopoly law is to serve as an effective check on powerful businesses, we must demand government enforcers who follow the vision of Congress and are willing to use and test their full legal arsenal. Thank you.
We've got a lot to cover here. We got a lot said in those three remarks. I have something that's kind of sticking out to me, which is we've got, there's a story up here about a lot of opportunity for enforcement, not clear sense that the law really is so limited as consensus. And I guess one of my questions is how did we get this consensus I mean, is it the ABA that sort of creates this sort of consensus where everyone agrees that the law isn't really that broad? Is it consumer welfare? Where did the kind of consensus that not much can be done on monopolization, where did it really come from, and how is it reinforcing, and how have we recently broken out of it? Yeah.
I think that there is a lot of consensus, everybody reads it, on that there's a problem. I mean, your average consumer knows there's a problem with Amazon, even though antitrust establishment can't. There are some things that are transparent when you live your life and you see how things operate that people. So on the problem, there's very high consensus. Obviously, in this politically polarized situation, that's an achievement right there. So I think, but solutions, I think, are a lot harder. And remedies are even harder. And that's where the politics get in. But I'm encouraged here because I think, there's a very, very high bipartisan understanding now that there's a problem. I think what changed, I followed this for 12 years and, all over Google issues. And the most amazing thing I saw was when Vestager came out and fined Google and convicted Google. Not that she did that, we expected that. But then everybody looked around and said, what would happen? Crickets. No one came to their defense on either side of the aisle. There one congressman did, but not very, very loudly. And that was, I think everybody looked around and all of a sudden, kind of the fear of saying anything or talking about everything really disappeared. And you just saw a avalanche or a tsunami or whatever you want to have going. If you go back and look at the media about the change in people's thinking, it happened right around after Amazon said it was going to buy Whole Foods, and then 7 or 9 days later, the other decision came. And if you just did a search on these items, you will see the spike then, and it grew. So people now understand there's a problem. This stuff is really complicated. I'm encouraged. It isn't like people are going to unsee this or unfeel this. When people now know that these companies are dominant and there's a problem and there's a concern, they're not going to then turn around in 3 years or 5 years or 10 years and say, when it's getting worse and when it's growing and the problems become more apparent, they're not going to say, oh, now I feel comfortable. The trend line is clear. The concern is going to grow. The question is how much it grows and whether that concern translates into something or a little bit or nothing.
Yeah, Lena, you went through an experience where New America kicked you out following Barry's statement about, sort of, I thought, mildly cheering on Vestager in that case. Was that a turning point? Did you see something happen then, or is there something else that's sort of changing the tide?
Yeah, I mean, I think we were definitely taken aback and surprised by the level of attention that incident received. I think it's partly because a lot of people have this sneaking suspicion that think tanks are corrupt, and so this was a story that validated that for a lot of people. To go back to your earlier question, I mean, I think on the private enforcement side, there's no doubt that Section 1 cases are easier to win than Section 2 cases, and antitrust litigation is expensive, and so, when faced with decisions about what to pursue, it's just going to be more likely that private firms will be pursuing Section 1 cases in a larger volume. I think on the government side, it's less understandable why we've seen such a huge asymmetry. I mean, I think in some instances there's a fear of making bad law, but that certainly can't account for all of the instances in which we've seen kind of reservation and a very hands-off approach. And so I think, the government is where we should be expecting or hoping that we see more aggressive enforcement on the monopolization front.
And Sandeep, I think you've done a lot of work documenting or at least following some of the failures of the policymakers and law enforcers of living up to their own stated interest in keeping prices and low and focusing on output. What's your take on how has this kind of consensus that seems a little bit divergent from what your actual findings are when looking at the law? How has it prevailed, and how is it threatened? Why is it threatened now?
Yeah, I mean, the ABA Antitrust Section has a clear interest in pushing this narrative. I mean, let's describe it for what it is. It's the vehicle of the corporate defense bar, and they have deep interest in ensuring that monopolization cases are seen as unwinnable as a means of deterring both private and government plaintiffs. So they have a vested interest in this dominant narrative. I think the agencies also have an interest because they are risk averse, almost pathologically so. And so if they can say, look, Trinco and Brook Group make it impossible to win cases, we're not going to devote resources to surefire losers, that makes it easier for them to focus on sort of small bore price fixing cases and ignore the structural issues facing our economy.
I could sit here and ask some questions all day, but I want to open things up. Do we have any questions in the audience? Frank?
I just wanted to ask about state enforcement efforts, if there's any hope on that level, or are the digital giants so big that it would just seem inappropriate for the states to be involved?
I wrote an op-ed when the Missouri AG came forward. You have to realize that the state AGs have been very aggressively trying to do stuff with Google for many years. They've, haven't really landed many blows, but the state AGs, this is something you have to remember, an AG is a future governor, a future representative or senator. They are, very ambitious, very capable people. It's the stepping stone to, a political career. And so a cabinet secretary is, a lot of people, start out there. And they have tangled with Google and the others, and tangled with all of the Internet Association on sex trafficking. And they because basically Google and the others have shut down their efforts to try and stop Backpage, which does 70%, because it would threaten their immunity as well. So I think the states are going to in a bipartisan fashion grow. It's pretty easy to predict that because they've come together. They can get 30 to 40 AGs pretty quickly on if they have an issue and they really want to focus on it. And the one that will energize them to do it is, people don't realize, Google got a federal injunction against one state AG that then applied for 15 months that said, a federal court said, you have no jurisdiction over these guys and you can't do anything. So they filed with 40 odd AGs, won that case on appeal, which that injunction never should have happened. But they realize Google basically, when they look at the state AGs, and Google was backed by Facebook and the other guys, they look at them and say, you're irrelevant to us. You don't matter. It's a federal law and we're immune and we are favored, and get lost. And if you don't get lost, we'll put you in a form of jail. It's an injunction. Literally, all 50 states were enjoined from enforcing consumer protection law for 15 months.
I think it's also worth remembering that the Microsoft case started as a state-level investigation, and in several key instances, we've seen the states be the ones that started investigations, and then the federal government kind of swoops in. So that's also true in the Monsanto investigation that the Justice Department was pursuing at the beginning of the Obama administration. That was also one that started at the state level.
The antitrust doctrine departs from federal precedents, so there might actually be more scope for holding these companies to account under state antitrust law than under federal antitrust law. So for example, in California, to establish a claim for predatory pricing, you only need to show below-cost pricing. You don't need to show this dangerous probability of recoupment, which is a huge advantage.
Yeah, so beyond broad subscriptions to investigative journalism and antitrust, what are some of the other solutions that we could see here to informing the agencies about anti-competitive conduct?
Yeah, I think it's really critical for these victims of monopolists to organize in some capacity to present their story, both to the agencies as well as the public. And I think furthermore, I think Tim's point identifies a real problem with antitrust doctrine today. It's just so fact-intensive that agencies need to have very, very detailed information before they can pursue a case. And oftentimes, who has that information? The monopolists themselves. So until we have simpler legal standards, it will be really trying when it comes to holding these big companies accountable.
That said, I think Tim's question also underscores what's a great virtue and asset in antitrust, which is that you actually have private interest pitted against private interest. And so it's not one of these areas of the law where you have a diffuse consumer interest that's pitted against a concentrated private interest. There are ways in which there are incentives built within the system. I think the question of like, how do you, ensure that the agencies are getting that information is an important one. That said, I think in the context of the tech platforms, we have seen the agencies kind of go in some perverse directions without necessarily thinking about the market as a whole. So I think, the ebooks case would be one example where there's some debate about, yes, on the one hand, they were found to be violating the law in this very narrow sense, but if you look at the larger structure of the market, I think in the, in the Google investigation with the FTC that we saw something similar reluctance. So I think on the part of victims of some of this conduct, there's also a sense that the agencies are not necessarily like responding to their concerns. But
Well,
now, I want to add something, is that you're describing yet another facet of the weakness of the Sherman process. And we know it's expensive, we know, it's fact-based, it's difficult and whatever. The method of my madness in describing this problem is there's monopolizations that are evident, and I documented them. I mean, the numbers there are like we've not seen for decades. So they're real. We can quibble whether it's the process of monopolization or monopolies. The reason I spent so much time on cartel behavior, why do you think I've focused on that? One guess. Completely different legal standard. Not only is it occurring and it is rampaging throughout the marketplace, Tim, you know this, it's a per se illegal standard. The two of you are found colluding and driving prices, either dividing markets or allocating customers, and you are illegally profiting from that. If I just prove through emails or conversations or with witnesses that the two of you did that, it's per se illegal. I don't have to talk about whether it's consumer welfare. Was this 51% innovative net? Was this 51% consumer benefit? You don't even have it. You have to remember that the Silicon Valley inoculated themselves from antitrust because there's a book called Information Rules. It's basically the antitrust book for information technology. And one of the authors, Hal Varian, has been Google's economist for 15 years. And basically they said is, you're okay with antitrust in this world if you can make an argument that you're pro-consumer, consumer benefits, and you're pro-innovative. And basically, you don't have to worry about Sherman. So you have that going on. Now, the reason I'm talking about cartel, this is a game changer if people start focusing on it and start investigating cartel behavior and not just monopolization behavior. Because then, look, on this cartel behavior that I just described, it's not like there are dozens of people that know what's going on. There are hundreds, and in some places there are thousands. And so getting people to come forward. Now you should know that in the Clinton administration, Ann Bingaman came up with a very novel innovation of enforcement. And she created an amnesty provision. I call it the Fink rule, where basically whoever comes in and thinks first gets amnesty. If you come in 1 second later and you're the second one, you get the book thrown at you. And it's proven very successful in cartel enforcement. And so I'm raising this little question of saying, monopolization's occurred, monopolization law is difficult. Cartelization is rampant. Cartelization investigation is easier, and it is very easy to prove if you have the facts, or you can construct that yes, they did collude and that there was some anti-competitive effect. And so my simple recommendation here is we can lament about all the problems with antitrust law and circle around and not get anywhere. But if people are serious that if they believe, and other people need to do the work, and do the research and look into the cartelization dynamic. It's clear, it's obvious, and people aren't focused on it. That's the area, and also Tim and others can say, that process can be relatively quick. It's not a 5, 7, 9-year process. Cartel enforcement, once people start confessing and they start talking, this is a process that takes months, maybe a couple of years.
I also, before, I want to ask Sandeep to follow up here, but I'm also curious what people on the panel think of this as not a access to information issue, but more of a personnel issue, because what we've found in investigating potential monopolization cases and things like that, you look at an industry, and the person at the FTC who allowed all the consolidation to happen in a sector in which you're now worried about, or people are coming forward, or there's writing about monopolization occurring, and they said, well, we let 11 of these mergers go through. You're asking me to then go find reasons for why these companies are now doing something wrong. It's pretty awkward, I would imagine, taking that meeting. And you see this in healthcare, I think, most particularly, but you also see it, I think, a lot with these Google cases. Is personnel really an issue now that people are now saying, well, maybe some of these mergers were not the best idea, that you have those same people kind of defending their intellectual and economic arguments that they made to allow those deals to then be asked to then enforce a monopolization. I mean, that's something that I see come up, but I don't want to, if people don't agree, that's fine, but.
I mean, I think intellectual and cultural capture are very real, and so I think those are issues that you see with regards to the antitrust agencies, for sure.
Okay, yeah, Cindy.
I think it's absolutely true, and I think even enforcers have internalized this notion that they need to have tangible documentation of effects before they have a colorable claim. It's not sufficient that a monopolist is locking its competitors out of distribution channels. They need to show consumer effects. And so the Borkian view has really permeated the entire antitrust community, and we're seeing the results of that. One point I wanted to make earlier is 30 or 40 years ago, injured consumers and businesses would have had a powerful tool at their disposal to use against Google and Amazon called a class action. Unfortunately, the Supreme Court has made it very, very difficult for private parties to vindicate their rights, and it's especially true on antitrust claims. So today it's effectively the government does something or the law is not enforced.
I think it's also worth considering what kind of information gathering the agencies are doing independently. I mean, the FTC, when it was formed, the economists, their main job was to collect data and information very regularly. And through the 70s, we had programs like the Line of Business Survey, where the agency very regularly collected data on industries. My understanding is that some of those efforts have been scaled back in ways that maybe impoverish their understanding of some of the kind of day-to-day dynamics of certain markets.
Yeah, I've looked into what kind of data the agencies have access to, and sometimes they'll say, well, we can't afford the industry data that's provided by a company that they allowed to buy all its competitors and charge them a huge amount. So IMS Health is the one I'm particularly talking about, which is pretty funny. But does any other questions here? Yeah.
Sandeep, you just mentioned conversations ago that antitrust enforcement may be too fact-intensive. I mean, what's the alternative? Because again, you're going to, for better or for worse, a generalist, a federal judge, you need to convince them that you've got a real story here and real factual harm and evidence. So what's the alternative? How could antitrust be less fact-intensive when you're dealing with you have to prove a case before a court of law?
I think the simplest alternative would be greater use of per se rules and presumptions. So, through the 70s, we had per se rules and presumptions governing a range of conduct. So in the merger front, we had the Philadelphia National Bank presumption, which said a horizontal merger that resulted in a market share of 20 or 30% was presumptively legal. So I think something like that would be much more administrable and also greatly enhance the effectiveness of the law. Because these rule of reason cases end up being multi-year investigations and litigations in which really everything and anything is relevant to the inquiry, and that both diminishes deterrence and really increases the cost of litigation.
A merger case and the Philadelphia National Bank presumption and per se rules on conduct, I mean, to me, those are just really inherently different. And so it does seem to me, look, I'm generally very pro-enforcement and very strong on wanting to stop anti-competitive conduct, but it also just doesn't seem to square that you could say any conduct that looks sort of like this is automatically per se illegal. I mean, we kind of had that, we moved away, and I'll be the first one to say I didn't like the Legion decision, but I think it's pretty hard to categorically say that, you know, any conduct that we might think is anti-competitive should be per se illegal.
I wouldn't say necessarily per se illegal. I think we can look to the European Union for guidance. So in the EU, the abuse of dominance standard holds that dominant firms can't engage in certain forms of conduct. And if they do, they have to come forward with a business justification to show what they're doing is benign. So we could easily, over time, adopt similar structured rules of reason in the U.S.
Also, isn't it a bit of a chicken and the egg thing if you've allowed a lot of mergers that aren't, you know, ostensibly you'd have fewer monopolization cases if you had done your merger reviews with all this, you know, kind of a lower bar to litigate them. So it's a little bit of a chicken and the egg issue there. Yeah.
One of the problems with the Clayton Act is that, you know, that actually, there is an opportunity that if a company misled the DOJ or the FTC in the review, you can go back and undo a merger that was approved. Because basically, if you prove that you were, they didn't tell the truth, or they were fraudulent, or misrepresented something. And like, for example, with Google, I mean, you know, you could, you know, go back and undo, you know, well, first of all, DoubleClick, I testified before the Senate, I said, you put those two companies together and you will have a monopoly. It's done. And so it was a no-brainer. And they let it through and it happened. So if DoubleClick was ever undone, or if when they were allowed to buy AdMob, at the time AdMob had 50% of the mobile advertising business. It was number one and Google was number two. And they allowed it and they came in, you know, basically Google convinced them that Apple was going to come in and be a, you know, a major advertising force. iAd went nowhere. And they approved that one. And surprise, surprise, they, you know, dominate, you know, mobile advertising and left Microsoft in the dust. So, I mean, those are just two. I mean, Facebook, you know, WhatsApp and Instagram. I mean, those were the number one and number two competitors after they knocked off Google Plus through collusion. But I mean, those are like no-brainers. I mean, that's basically Facebook did what AT&T did in the early 1900s. It basically went around and bought networks up. And when you add a network into another network, you create the dominant network. That's all Facebook has done. And, you know, and Instagram and WhatsApp basically were coming in new areas which could have changed the game, and they basically were absorbed into them, and they became an AT&T like monopoly via acquisition. So Facebook's troubles are Clayton problems, where, you know, they should never have been, but of course that was the 4-year period, the second part of the Obama administration, where those companies could do no wrong, and they had. We won't go in deep there, but everybody knew that what they wanted, they got.
Before we go, I want to ask one last question. Really quickly, if you were in a position of power, head of FTC or chairman of the FTC or at DOJ, what would be the thing that you would do that you think is currently within the law that should be done to address any kind of enforcement issue, monopolization issue that you think should happen in this area?
I'd probably start with Section 5. I think Section 5 gives the FTC so much latitude to make better antitrust policy, and using Section 5, I think I would impose special duties and restrictions on dominant and near-dominant firms. So, you know, Amazon with its 60 or 70% share in the ebooks market would not be allowed to sell ebooks at below cost under my vision of the Section 5 authority. So I think that's a powerful tool, and the courts would probably grant the FTC deference on its interpretation of Section 5 because of modern administrative law, such as Chevron deference.
Lena, Scott?
We'll go just down. It would make cartel enforcement the number one priority because it's the most important part of antitrust law, and those violations are the most serious and severe. Therefore, they have the most severe penalties, and because the process can be done most effectively. So it would just be simply saying, let's make our priority be cartel enforcement rather than focusing on Sherman cases.
I'd agree with Sandeep on the Section 5 issue. I think I would also just scrutinize
That's my opinion, sorry.
acquisitions by dominant platforms a lot more closely, even when they don't trigger HSR review, or even if they're kind of vertical or conglomerate deals in ways that are not triggering traditional concerns. I mean, I think the fact that the FTC didn't even issue a second request in the Amazon Whole Foods deal suggests that the way they're thinking about these mergers are at odds with the realities of how these markets actually operate. So I think in addition to the Section 5, just kind of applying a lot more scrutiny with regards to dominant platform acquisitions.
All right, please give a round of applause to our panelists here.